Sir has joined us. Welcome, sir. Good morning.
Good afternoon and a warm welcome to panel discussion on Consumer Protection Act 2019, organized by the Tamil Nadu Dr. Ambedkar Law University School of Excellence in Law in association with COVAS Foundation, Conflict Resolution International, on account of World Consumer Rights Day 2022. We celebrate World Consumer Day every year on this day to highlight the importance of the consumer movement and need to make every consumer more aware of their rights and responsibilities. This Consumer Protection Act 2019 is a law to protect the interest of the consumer. This act was inevitable to resolve a large number of pending consumer complaints in consumer courts across the country. It has always and means to resolve the consumer grievances speedily. The basic aim of the act is to save the rights of the consumers by establishing authorities for timely and effective administration and settlement of consumers. Today, the panel has set up to discuss the provision of Consumer Protection Act 2019. Now, I request Ms. R. Aarti Ratna, Assistant Professor, School of Excellence in Law, to deliver the welcome address.
Am I audible? Thank you, Vignesh. A very good morning to one and all present here. It gives me immense and great pleasure to grace this occasion. Today, we all have gathered for the panel discussion on Consumer Protection Act 2019, organized by School of Excellence in Law, Tamil Nadu Dr. Ambedkar Law University, in association with COVAS Foundation, Conflict Resolution International, on account of World Consumer Rights Day. When we approach the market as a consumer, we expect value for money, quality, right quantity, right prices, informations and instructions of the product. But there may be instances where the consumer could not meet his expectation. The Consumer Protection Act 2019 gives easy and fast solutions to consumer grievances. It safeguards and encourages consumers to speak against insufficiencies and if there is any flaws in goods or services. As Mahatma Gandhi said, a consumer is the important visitor on our premises. He is not dependent on us, we are dependent on him. He is not an interruption on our work. He is the purpose for it. He is not an outsider on our business. He is a part of it. We are not doing him a favor by serving him. He is doing us a favor by serving as an opportunity to do so. Words of our Father of Nation has come alive by Consumer Protection Act 2019 by ensuring safety to consumers regarding defective products, dissatisfactory services, and unfair trade practices. The new act provides flexibility to the consumers to file complaints. Further, to introduce the concept of product, it introduces the concept of product liability. The new act fixes liability on endorsers, considering that there have been numerous instances in the recent past where consumers have fallen prey to unfair trade practices under the influence of celebrities acting as brand ambassadors. And also, this act provides for mediation as an alternate dispute resolution mechanism, making the process of dispute adjudication simpler and quicker. Gone are the days where the consumers were asked to be aware. Now the rule is caveat vendita. Not only the seller, even the consumer has certain responsibilities. So the object of this panel discussion is to educate the consumer about their responsibilities and enlighten the consumer about their rights, which is guaranteed under this act. At this outset, I would like to welcome the dignitaries of this program. It's my privilege to welcome our Honorable Vice Chancellor, Professor Dr. N.S. Santhosh Kumar, sir, who is a visionary of this university. Under Sir's leadership and guidance, legal studies have achieved greater heights. I welcome you, sir. I further like to welcome our Dean, Professor Dr. Balaji, sir, UG Director, Dr. Bhuvneshwari, Madam, PG Director, Dr. Kumuda Ratna, Madam, IQAC Director, Professor Dr. Reddivari Revati, Madam, and all head of the departments and all assistant directors. Further, I would like to welcome all the panelists of today's discussion. Chairperson, a person, Dr. R. Harita Devi, Madam, Associate Professor, Director in charge of Research and Publication. Another chairperson, Dr. Ranjit Oman Abraham, sir, Registrar in charge, Tamil Nadu Dr. Ambedkar Law University. Mr. Inbavajian, sir, Managing Partner, KFC RI. Ms. Divya, Madam, Assistant Professor, School of Excellence in Law. Mrs. C.R. Aishwarya, Madam, Assistant Professor, School of Excellence in Law. Mr. Rahothaman Sir, Research Scholar, Tamil Nadu Dr. Ambedkar Law University, Mr. Mayappan Kumaran, Faculty, School of Excellence in Law. And I welcome all the participants, students, research scholars, and all other staffs of Tamil Nadu Dr. Ambedkar Law University for the program. I welcome you all. Thank you.
Thank you for the warm welcome, ma'am. In today's panel, we have astonishing panelists joining us to address the elaborate insights about the Consumer Protection Act 2019. First now, I call upon Dr. Ranjit Oman Abraham sir, Registrar in charge for the Tamil Nadu Dr. Ambedkar Law University and chairperson of this channel. Sir has presented and published articles relating to IPR and business law. Sir has done several projects and papers in Germany, USA, and Singapore. Dr. Ranjit Oman Abraham sir also served as a faculty coordinator in trade license project of Tamil Nadu government. I invite sir for the opening remarks.
A very good morning to all of you. It is a great privilege on me for giving this opening remarks on this very important day, the World Consumer Day. And I'm also very happy that our university, Tamil Nadu Dr. Ambedkar Law University, is celebrating the World Consumer Day with a very good panel discussion lined up, where extremely good speakers are going to speak on various aspects of Consumer Protection Act. All of us know that our university is specialized in many departments where we have postgraduate departments, and also other than that, also our university is doing certain researches in very important areas of law. And one of the most important area of law is consumer protection, where our university has done remarkably a wonderful job, because we had a chair, which many of you might not know and some of you may know. We had a chair of excellence in consumer law and jurisprudence, which is in short form called CECLJ. Now this chair worked from 2014 to 2019, and I got the opportunity to be the project director of the chair for 1 year. So before me, it was Dr. Balaji sir, our dean, who was the project director for 4 years. When this chair was there, we have done a lot of work, research, surveys we have taken, we have conducted workshops, we have conducted programs in various villages on consumer awareness, and we continue to publish a lot of important material relating to the old act, because this chair was in the period of the old act. But after this chair was over, we have the new act, 2019 act, and from that time onwards, the Ministry of Consumer Affairs, due to some procedural issues, they are not able to renew the chair, because they have not done it for anyone in India. All the renewals are stopped because of the COVID pandemic and certain procedural issues. But still, Tamil Nadu Dr. Ambedkar Law University is their favorite, because whenever they want any research, they immediately come and ask us. And so I'm like a contact point for them, because I was the project director in the last year. And now, when they asked us that none of the law schools in India have time to publish some material on the 2019 Act, will your law school do? So we have good faculties. Most of the members in the panel today are all, our faculties whom we consulted, and they all, without any hesitation, said yes. So firstly, I'd like to congratulate all the panelists. Infovision sir is an expert panelist who's also part of our university. So I'd like to record this, that all the panelists immediately said, yes, we will do it, sir. And they were the faculty who were responsible and who took day and night. They worked within a very short span of time. And what they did is they published this Consumer Protection Act 2019. And I take the privilege as a registrar of this university, as an alumni of this university, I take the privilege to tell that now at this moment, our publication is going to be released by the Government of India, Ministry of Consumer Affairs in New Delhi by the Union, none other than the Union Consumer Minister. And this first copy will be received by our Honorable Vice Chancellor, who has gone there physically, along with our Dean. It's a great matter of great pride that our university has done that, for which the team led by Harita ma'am Aarti Ratna, Divya, Aishwarya ma'am, and Raghotaman sir, and also Arun and Mayappan sir. All of them have contributed along with extremely talented students. So even the students have also worked very hard, and they have done this publication. So when we see this publication, we'll be very happy. It's not one publication. We have done two publications. One on Consumer Protection Act. That is the student editors are Charisma, Geetanjali, and Rasika, and also Vignesh, who's our more compeer today. And also on product liability, also a team of students have done. And I think maybe Aarti ma'am will be able to tell more on this particular aspect little later. So I'm very happy to tell this at this occasion. And we know that Consumer Protection Act 1986 had so many problems, so many loopholes, so many issues. So the government wanted to make a change. They wanted to bring a new law. They brought 2019. Still, we have certain problems which they need us to research and tell the problems so that they can go for amendment. So the ultimate aim of this panel discussion is to find out the efficacy of the 2019 Act. With various new features they have added. They have added mediation as a method to resolve consumer dispute. We have Ambedkar sir, who's an expert in ADR, and today we have associated with KFCRI, which is nothing but his that KFCRI is his own brainchild, and they are doing a lot of work in doing a lot of workshops, seminars, conferences, training programs, and we are very happy to sign an MOU with that institution so that we join hands for giving practical input for our students. Academy will be successful only when theory meets the practicality, and that is what is happening today also. So that is what I'd like to tell you that uh, I'm sure this panel discussion will take all the important steps with regard to these issues, whatever our speakers are going to speak about, and will be resolving the same. So I wish everyone the best. I wish the participants also the best to hear. And my sincere thanks to all the students and the teachers who work for helping our university to publish two important publications on this World Consumer Day. Thank you very much.
Thank you, sir, for your valuable speech. Now I request Ms. Divya, Assistant Professor, School of Excellence in Law. Madam has completed BL and Masterate in Business Law from the esteemed Madras Law College, and Madam was awarded Gold Medal for her outstanding performance both in UG and PG. And Madam also published their papers in national and international journals and seminars. I invite Ma'am to discuss about to introduce the Consumer Protection Act 2019 and Consumer Protection Council. Welcome, ma'am.
Yes, sir. A very good morning. Thank you, Vignesh, for introducing me. Oh, am I audible?
Yes, ma'am.
Yes. Thank you, ma. Yes, a very good morning to everyone present here. Today, I'm just going to discuss about Consumer Protection Act of 2019. It's just an introduction that I'm going to give when it comes to this Consumer Protection Act of 2019. Please move on to the next slide. Yes. I would like to start with a very famous quote as quoted by Emma Watson. As consumers, we have so much power to change the world by just being careful in what we buy. Yes, next slide, please. And here I'm wishing you all a very happy World Consumer Rights Day. And each and every year, March 15th is marked as World Consumer Rights Day. And this particular day, it's getting celebrated exactly, if you take and see, from the year 1963. That is what is the memorable moment of that particular day? Why we are celebrating it is on March 15th is on this particular day, that is March 15th in the year 1962, it honored the speech rendered by the then US President John Kennedy, who actually coined the four important rights of the consumer, particularly to state the right to safety, the right to be informed, the right to, that is the right, and the right to be heard, the right to be protected and the right to be heard. All these four important consumer rights was coined by John Kennedy in this particular day, and from the year 1983 till today, and we are going to continue to celebrate the World Consumer Rights Day. So Definitely, I would like to wish each and everyone a very happy Consumer Rights Day, because in some way or the other, irrespective of caste, color, creed, religion, sex, nationality, we are all consumers. Yes, next slide, please. Yes, so if you take and see, just look into the history, we can better classify it into the pre-independence era as well as the post-independence era. Consumer protection legislations were there from time immemorial. Even if you take during the British era, especially to protect the consumers from the crimes that is actually getting conducted in the marketplace, various kinds of legislation was enacted by the British Parliament. One second. Yes, various kinds of legislations were enacted by the British Parliament, particularly to take even now. Now we are able to follow all these kinds of legislations, and we are following today. The Indian Penal Code 1860, the Indian Contract Act of 1872, the Sale of Goods Act of 1930, the Drugs and Cosmetics Act of 1940, etc. And what happened after we achieved our independence? Yes, the Indian Parliament also enacted various pieces of legislation to protect the consumers, particularly to take the Indian Standards Institution Certification Marks Act of 1952, the Essential Commodities Act of 1955, the Food Safety and Standards Act of 2006, the Legal Metrology Act of 2009, etc. Whether it is the British era or whether it is the Indian era, is there a particular piece of legislation to protect the consumers? Is there an exclusive piece of legislation to protect the consumers? And yes, after 40 years of our independence, that was fulfilled by us by enacting the Consumer Protection Act of 1986. Kindly move on to the next slide. Yes, and we add the Consumer Protection Act of 1986. What about this particular act? As I said, it was an exclusive piece of legislation. In the previous slide, whatever we looked was, yes, it was there to protect the consumer, but it was not an exclusive piece of legislation to protect the consumer. But now, earlier, that is at that point of time, after 40 years of independence, we add the Consumer Protection Act of 1986. And the particularity of this act, if you take and see, it came into force on July 1st, 1987, and the preamble of the act said that it aims to protect or to provide better protection for the interest of the consumers, as well as to establish counsel and other administrative authorities for the settlement of consumer disputes and for the matters connected therewith or incidental thereto. Now you can ask me, then why? Definitely, if you take and see, at that point of time, it was an act worthy to be appreciated. It was proved effect and it had a proper support. But now, if you take and see, this act is more than 30 years old and it is not capable to, that is, it is not actually capable to keep up with the growing advancement of technology, and especially to meet the needs of the traditional consumer as well as the modern consumer, as well as to fill the gaps that was there under the Consumer Protection Act of 1986. Thereby, the Indian Parliament enacted the next, that is at the latest. What are we going to discuss today? Please, the next slide. The Consumer Protection Act of 2019. Now, yes. So, what is the highlight of this particular Consumer Protection Act of 2019? That is the topic for today's entire day for discussion. That is this one. Next slide, please. When it comes to the Consumer Protection Act of 2019, it came into force. That is, it received the assent of the President, and thereby it was published in the official gazette on August 9, 2019. And thereafter, the new act came into force on such date as the central government notified. So when was the date that was notified by the central government? It was on July 20, 2022. That is 2020. Exactly to tell, after the COVID crisis only, we were able to get this most important piece of legislation to protect the traditional consumers as well as the electronic consumers, or else you can famously call it as the online consumers. What is the preamble of the act tells? Yes, an act to provide for the protection of the interest of the consumers and for the said purpose to establish authorities have to be established for timely, that is most needed, for timely and effective administration of settlement of consumer disputes and for matters connected therewith or incidental thereto. So to put it in a gist, I can very well tell that Consumer Protection Act of 2019 aims to strengthen the consumer protection rights. That is, what are the rights that has been conferred to the consumer? Fine. But those rights needs to be strengthened. It is not just for the namesake we are telling this right is available for the consumer, that right is available for the consumer. Those rights needs to be strengthened extent the scope of consumer grievances needs to be addressed, and most importantly, an ease should be provided. Easily in the process of filing a complaint, without any difficulty for a consumer, they should be able to redress their grievances. So this was the target point of the Consumer Protection Act of 2019. Next slide, please. Yes, the next slide. Thank you. Yes, sir. This act, if you just take and see, what about the structure of this act? The act comprised of 107 sections divided into 8 chapters. And chapter 1, preliminary, as we all know, it spoke about the short title, extent and commencement, and most importantly, section 2, which portrayed on definitions. One interesting thing I would like to tell is that many new terms are defined when compared to that. I was telling about 1986 Act, right? So when compared to that of the 1986 Act, in the 2019 Act, many new terms have been defined. For that particular act, it is a new term because it has not been defined anywhere, especially to protect the consumers. Take, for example, advertisement. Misleading advertisement has been defined, product liability has been defined, electronic commerce has been defined, electronic commerce service provider has been defined, mediation has been defined. So all these are some of the new definitions that finds a place under section 2 of the latest Consumer Protection Act of 2019. Next, chapter 2, which is going to speak about the Consumer Protection Council from section 3 to 9. Chapter 3, Central Consumer Protection Authority from section 10 to 27. Chapter 4, Consumer Dispute Redressal Commission from section 28 to 73. Chapter 5, Mediation from section 74 to 81. Chapter 6, Product Liability from section 82 to 87. Then chapter 7, Offences and Penalties from section 88 to 93. And last but not the least, we have the chapter 8, Miscellaneous, that is from section 94 to 107. Yes, next slide, please. Yes, sir. Now we will be having a doubt. What could be the effect of the cases that was filed before the coming into force of this new act? Yes, sir. Very well, we all will be having a doubt. When there is a repeal of an existing legislation, that is, we all very well know, Consumer Protection Act of 1986 has been repealed, and in that place, a new legislation has been placed. Then what will happen to the cases that is pending under the previous act? And this doubt has been very well clarified by the last section of the Consumer Protection Act of 2019. And the last section is section 107, which clearly makes us an understanding that the earlier Consumer Protection Act of 1986 has been repealed. So in the same section 107, they have also given us a clarity that we have to refer to section 6 of the General Process Act of 1897, which tells that any cases, that is any legal proceeding that are started under the existing legislation shall not be affected by the repeal of this particular legislation. And the same was reiterated by the Supreme Court in the case of Security Exchange Board of India versus Classic Credit Limited. Yes, the next slide, please. Salient features of the Act. Yes, what could be the salient features of the Act when compared to that of the 1986 Act? We are telling it is a big boon, the Consumer Protection Act of 2019. In what way it stands to be greatest boon when compared to that of the 1986 Act? Yes, first of all, let me just tell you all, the definition part has played a very crucial role. When you take and see, consumer has been defined. Yes, even in the previous act, consumer was defined. I'm not telling no, but here a broader perspective has been given to the definition of consumer, who tells that, and that particular definition clearly makes us understand that a person who is going to engage himself in online or offline transaction. So now the word to be noted by us is the online transaction. So a person who is going to involve himself in online transaction can also be brought within the purview of a consumer. So this is the definition that has been so stated under section 2(7) of the Consumer Protection Act of 2019. Similarly, as I was telling, there are various rights of the consumer that needs to be protected. But whether the rights are given statutory protection in the previous act means no. So if you take the right to safety, the right to be informed, the right to choose, the right to seek grievance, the right to consumer awareness, all these are various kinds of rights. And these rights have been particularly defined under section 2(9), gives the statutory recognition to the consumer rights, and the consumer rights has been defined under section 2(9). So this is one of the biggest added advantage of the latest act. So next, if you take and see the enhanced pecuniary jurisdiction, and we all know about what is the pecuniary jurisdiction. It will be assessed. That is, pecuniary jurisdiction means it will be assessed. The jurisdiction will be assessed on the basis of the value of goods and services paid as consideration and not on the basis of relief. So if you take even in the previous act, yes, pecuniary jurisdiction was there. We cannot say it was not there in the previous act. It was there. Was there for the district commission, state commission, and national commission. But the biggest advantage of this particular piece of legislation is that it has been enhanced. That is, for district commission, the pecuniary jurisdiction is up to 1 crore rupees. That is, thereafter for state commission from 1 crore to 10 crore rupees, and for national commission it is above 10 crore rupees. So this is the enhanced pecuniary jurisdiction when compared to that of the previous act. So next, if you take and see, this is another added feather, a new feather in the cap of the Consumer Protection Act of 2019 is the establishment of the Central Consumer Protection Authority, CCPA. It has been so constituted and it has been dealt under Chapter 3 from Section 10 to 72. It clearly speaks about Central Consumer, I guess it is from Section 10 to 28, Chapter 2, which clearly speaks about Central Consumer Protection Authority. So the role played by the Central Consumer Protection Authority is the regulation of violation. If there is going to be any violation of the rights of the consumer or violation of unfair trade practices and particularly violation of misleading advertisements, then they are the regulator who will be regulating all these issues. Most importantly, they have got an investigation wing. They have got the power to conduct an inquiry or investigation with the help of this particular person called as the Director General. Next, very interestingly, the concept of product liability. We used to purchase a product, and if there is a defect, means we will not open our mouths and we don't know where to do, where to go, what to do. And that problem has been solved, I guess, to a great extent with the help of the product liability that has been covered from Section 82 to 87. So what is this product liability? If there is going to be a defect in goods, not only defect, what we all know, defect in goods or deficiency in service means, so definitely if you take and see, the manufacturer or the service provider will be put to liability, will be put to, that is, they'll be put as liable for the defect in product or deficiency in service, and more importantly, compensation can be claimed as relief is the biggest advantage of this product liability incorporated under the latest act. So next, if you take and see, we have got alternative dispute resolution mechanism where the consumer disputes can be settled with the help of a mediation, either at the start, that is, if you take and see, either at the start of the complaint or at any stage, the consumer dispute can be settled, but the consent of both the parties is required in order to proceed it, and a mediation cell is attached to the district commission, state commission, as well as to the national commission, and there is no appeal. So once the judgment has come, there is no appeal, there is no further appeal. So next one, if you take and see, very well, we will be understanding about the penalties for misleading advertisements. So misleading advertisements, even we are pranked and we are fooled, only we can say because of this misleading advertisements. Whether they are literates or illiterates, easily we are falling into the trap of misleading advertisements. So now if you take and see, penalties have been imposed for misleading advertisements. Not only that, the term, as I said, the definition section has been made stronger. The section 2/1, the very first definition itself tells us what is an advertisement, and section 2/28 makes us an understanding about what is a misleading advertisement has also been defined. So very simply to take and see, now the penalties have been imposed up to 10 lakh rupees, and it will be imposed upon the manufacturer or endorser of that particular product. And in addition to the penalty, an imprisonment is also supported, and that imprisonment may extend to 2 years as per this latest provision. Next one, definitely e-commerce, electronic commerce. So without speaking about electronic commerce, we cannot protect the latest consumers, or we cannot protect the modern consumers. So if you take a see, as per the latest report that I have read, it shows that 70% of the Indian citizens who use their mobile internet services are addicted to online shopping, or they go for online shopping. So now it is a scenario where more than that we have forgotten the traditional shopping and slowly we are addicted towards this online shopping. And at the same time, we are deceived. We are cheated many times because of this online shopping. And e-commerce, if you just take and see, section 2 clause 16. What is the benefit of this particular e-commerce? Whether it has been addressed under the Consumer Protection Act of 2019? Yes, very well. Section 2 clause 16 defines and tells us what is e-commerce. E-commerce includes buying or selling of goods or services, including digital products over digital network. So that is what is e-commerce. And in addition to it, we have also got the latest rules that have been implemented. Very well, we can just take it as the e-commerce, that is the Consumer Protection E-commerce Amendment Rule of 2021 has come into place. And the next one, if you take and see, the power to review. Yes, very clear. Even under the earlier act, the power to review its own order. If there is going to be a factual error, who can review its own order? It was only the National Commission who was empowered to review its own order in case of a factual error. But now the same right has been granted to the District Commission where they can review its own error, as well as to the State Commission where they can review its own factual error. So these are some of the salient features. Much more features are there, but these are the key most important features of the very latest Consumer Protection Act of 2019. Next slide, please. Yes, and in addition to that, let me also let you all know about the rules. We have the Consumer Protection Act of 2019, but is there any rules that has been associated with it? Yes. At the latest, the rules are overflowing, especially to protect each and every aspect of the Consumer Protection Act of 2019. So if you take and see, the Consumer Protection, Search and Seizure and Compounding Offences by the Central Authority and Crediting of Penalty Rules 2021. And next one, the Consumer Protection Jurisdiction of the District Commission, the State Commission and the National Commission Rules 2021. Third, the Central Consumer Protection Authority Form of Annual Statement of Accounts and Records Rules 2021. The Consumer Protection Jurisdiction of the District Commission, the State Commission and the National Commission Rules 2021. The Consumer Protection Direct Selling Rules 2021. Consumer Protection E-commerce Amendment Rule. As I was telling in the previous slide, the Consumer Protection E-commerce Amendment Rule of 2021. Kindly the next slide. Yes, sir. So now let me just move on to my next part of our presentation or discussion. It is with reference to Consumer Protection Council. So let us just understand about what is this Consumer Protection Council that has been so established under Chapter 2, particularly from Section 3 to 9. Yes, sir. So what is the role played by this Consumer Protection Council? We are speaking that the consumer rights needs to be promoted, protected. Yes, that is fine. But for example, a layman is that he has purchased an Android mobile phone worth rupees 30,000 and within a period of 2 weeks, if it is not working, means it is a defect in the goods. But he as a layman doesn't even know that it is a defect in the good and what kind of remedy he has got, he don't know whom to go and approach. In that case, one of the best advisory body whom he can very well go and approach, it could be none other than the Consumer Protection Council that has been so constituted. So if you take and see, as I said, they act as advisory body and assist the consumers in seeking and enforcing their rights. If they need their rights to be protected, they can very well go before the Consumer Protection Council who will be acting as an advisory body. And as I said, it has been done under Chapter 2 from Section 3 to 9 generally speaks about the Consumer Protection Council. And in order to safeguard us, that is, it is not necessary in each and every level they have constituted this Consumer Protection Council. For example, Central Consumer Protection Council is there, state consumer protection for each and every state it is there. In that state itself, if you take district, even for district Consumer Protection Council is there. Yes, the next slide, please. Yes, sir. Let me just tell you about the Central Consumer Protection Council. As I said, it is from Section 3 to 5. Who has got the power to establish the Central Consumer Protection Council? It could be none other than the central government. And the Central Council, as I said, it will be acting as an advisory council and consists of the following members. As it is a council, it should consist of the minister in charge of the Department of Consumer Affairs in the central government, who shall be the chairperson, and at the present we all very well know it is Mr. Piyush Chawla. And next one, such number of other official or non-official members representing such interests as may be prescribed. Yes, the next slide, please. Yes, sir. So next, if you take and see, yes, the Central Council, as I said, it shall meet. It has to conduct a meeting. But when it can meet, whenever it is necessary for that, they can meet. and at least one meeting. But the important condition is that at least one meeting should be conducted each and every year. Their time limit is at least one meeting should be conducted. And at time and place as the chairperson may think fit, the meeting can be conducted. And most importantly, they have to observe such procedure in regard to the transaction of its business as may be prescribed. And next, very important, what could be the object of the Central Consumer Protection Council? It could be none other than rendering advice on promotion and protection of consumer rights under this particular act. In what and all ways the consumers can be protected, and in what and all ways their rights can be promoted. So this is the dream of this particular advisory body, be it whichever kind of Consumer Protection Council it is. And here I would like to refer to a rule that has been so constituted, that is the Central Consumer Protection Council Rule of 2019, and it was issued by the Ministry of Consumer Affairs, Food and Public Distribution on July 15, 2020. And in that rule, let me just explain about Rule 4 to you all, which tells about the term of the Central Council shall be for a period of 3 years, provided that the Central Council shall continue. That is, the time limit is 3 years. If they want, they can continue for a further period of 3 months or till another one is constituted, whichever is earlier. Yes, the next one. Now the same thing. Next slide, please. The same thing applies, where now from the central just come to the state. Yes, ma'am, before slide. State Consumer Protection Council. And the State Consumer Protection Council has been very well addressed under section 6 and 7. So now it is the foremost duty of the state government. Earlier it was the central government. So now every state government shall, by notification, they have to establish a Consumer Protection Council, famously called as the State Consumer Protection Council. And it again acts as, just like the other Consumer Protection Council, this also acts as an advisory council, and it should consist of the members, especially the minister in charge of consumer affairs in the state government, who shall be the chairperson. So now if you take and see, at present in the state government of Tamil Nadu, it is Thiru Shakarapani. He is the minister in charge of consumer affairs, and he will be the chairperson of this particular Consumer Protection Council. And not only him, such number of other official or non-official members representing such interests as may be prescribed. And another interesting thing in the State Consumer Protection Council, some members will be nominated by the central government. Such member of other official or non-official members and exceeding 10 may be nominated by the central government. So the role of the central government is also here, as they are nominating the members in case of the State Consumer Protection Council. Yes, the next slide, please. So the same thing, they shall also meet whenever necessary. They can meet, but the thing is that at least 2 meetings shall be held every year, and whenever they are meeting, it can be decided where they have to meet. That and all can be decided by the chairperson, and most importantly, they have to observe such procedure in regard to the transaction of its business as may be prescribed. So where it is getting prescribed, it will be prescribed in the rules very much particularly. And I think the objects of the State Council has been so illustrated under section 7, which tells that to render advice on promotion and protection of the consumer rights under this act, but most importantly to note that their jurisdiction is only within the state they can render the advice. Yes, the next slide, please. District Consumer Protection Council, and that has been dealt under section 8 and 9, which speaks about the District Consumer Protection Council. Now again, it is the role of the state government. They have to issue a notification and establish for each and every district with effect from such date as it may specify a council called as the District Consumer Protection Council. So for Chennai, if you take and see, here also we have got a District Consumer Protection Council, and again its role is also to act as an advisory council and consists of various members, especially the collector of the district, who shall be the chairperson. And if you take at present, it is Dr. J. Vijayarani is here, means, and she will be, that is the collector, deputy collector will be made as the chairperson of this particular council. And next, apart from it, that is apart from collector, such member of the official and non-official members representing with interest any matters that has been prescribed. Yes, the next slide, please. And the district council, again, as I said, they should also conduct meeting, and at least they should have conducted 2 meetings in a year, and that thing shall be according to that particular procedure that has been so illustrated, and wherever the chairperson decides, accordingly the meeting can be conducted, and also the proceedings can accordingly take place. Next, section 9, which again speaks about what will be the role of that particular district council. Means definitely they will also be rendering advice on promotion and protection of consumer rights under this act, and that too their role is confined only within the district. Yeah. So these are the three consumer protection councils: Central Consumer Protection constituted at the central level, State Consumer Protection Council, where we have got Tamil Nadu Consumer Protection Council, Karnataka Consumer Protection Council, Kerala Consumer Protection Council, and very well, even in the state of Tamil Nadu, for each and every district it has been constituted. Next slide, please. Yes, sir. So I'd like to come to a conclusion with my discussion by just quoting a very famous quote as quoted by Vivian Westwood, who tells that buy less, choose well, and make it last. Yes, and I thank each and everyone for giving me this beautiful opportunity to present with reference to the Consumer Protection Act of 2019, and that too on the World Consumer Rights Day. Thank you, each one.
Thank you, ma'am. It was very informative, and thanks for elaborating Consumer Protection Act in an interesting manner, ma'am. Thank you. Our next panelist, Mr. R. Raghotaman, sir, research scholar, Faculty of Law in School of Excellence in Law. Sir has secured first rank in branch of business law in the year 2020, and sir is also the recipient of A.S. Venkatrama Iyer Gold Medal. Now, sir is currently pursuing his PhD in School of Excellence in Law, TNDALU. I invite sir to discuss about Consumer Dispute Redressal Commission. I welcome you, sir.
Thank you, Vignesh. Thank you for your nice introduction. Am I audible?
Yes, sir, you're audible, sir.
Thank you. Thank you. Now in this relay race, the torch has been given to me. My deliberation will be focusing on Central Consumer Protection Authority and Consumer Dispute Redressal Commission. So I will use the PPT to give my deliberation very well. Can you please confirm me whether my screen is shared?
Yes, sir. Yes, sir.
Thank you. Thank you. Get closer than ever to your consumer. So close that you tell them what they need well before they realize it themselves. By Steve Jobs. Your most unhappy consumers are your greatest source of learning. By Bill Gates. Yes, true. Consumer Protection Act 2019 provides for three different statutory bodies, namely Consumer Protection Council, Central Consumer Protection Authority, Consumer Dispute Redressal Commission. The first body was discussed by Divyana. Now, I will start with Central Consumer Protection Authority. By virtue of Section 18, the Central Consumer Protection Authority has been given a general mandate to regulate the matters related to violation of consumer rights, unfair trade practices, and misleading advertisements. It unambiguously clarifies that the central authority has the power to protect, to promote, and to enforce the rights of consumers as a class. Similarly, by virtue of Section 19, the central authority has power to refer matters for investigation or refer matters to other regulators. By virtue of Section 20, the central authority can order to recall the goods or withdrawal of services which can harm the innocent consumers. Since we have come across the terms consumer rights, unfair trade practice, and misleading advertisements, so we will understand what are the consumer rights, what is unfair trade practice, and what is misleading advertisement. As per Section 2, Clause 9, the consumer are conferred with the rights. The rights are the right to be protected against the goods or services which are hazardous to life and property, right to be informed about the quality, quantity, potency, purity, standard, and price of goods or services so as to protect the consumer against unfair trade practices, right to choose, right to be heard, right to seek redressal, right to consumer awareness. What is misleading advertisement? Section 2, Clause 28, it defines what are all the misleading advertisements. First, falsely describing the products or services. Next, giving false guarantee to mislead the consumers as to the nature, substance, quantity, or quality of such product or service, or likely to mislead as to the nature, substance, quantity, or quality of such product or service. Or conveying explicitly or implicitly the representation of unfair trade practices, or deliberately conceals important information. Now, what is unfair trade practice? Section 2, clause 47, it deals with unfair trade practice. First, making any statement. That statement might be in verbal or written format or visible representation, including the electronic mode. That statement which falsely representing the goods or services or of a particular standard, quality, quantity, or grade, or falsely representing old goods as new goods, or falsely representing that the goods or services have sponsorship or characteristics or benefits which they really do not have, or falsely representing the seller or the supplier has approval or affiliation, or making misleading or false representation regarding the need for the goods or services or the usefulness of goods or services, or giving warranty or guarantee regarding the performance, efficiency, or longevity of the products which is not based on the adequate proof, or misleading the public regarding the prices, or false or misleading facts disparaging the goods or services or trade of other person. These are all making the statements. Apart from this, permitting the publication of advertisement for the sale or supply at a bargain price of goods or services that are not intended to be offered, or not issuing bill or cash memo for the goods sold or services rendered. Here is the place, as a consumer, we are reluctant to ask for the bills, ask for the cash memo, and the seller or manufacturer, they are also reluctant to issue the bills for the services or goods they sold. Next, refusing to take back the defective goods after selling them, or manufacturing or offering of spurious goods, or disclosing the personal information of consumers unlawfully to other person. These are all unfair trade practices. Next, yes, complaints are there with the defective goods or defective services or unfair trade practice or misleading advertisements or violation of consumer rights. Where to give the complaint? This is the next question. So section 17 delineates the complaint relating to violation of consumer rights or unfair trade practice or misleading advertisements may be forwarded to either district collector or commissioner of regional office or central authority. So what are all the powers and functions of central authority? Section 18 subsection 1 delineates the powers of central authority. The central authority has power to protect, to promote, and to enforce the consumer rights and prevent violation of consumer rights. The central authority has power to prevent unfair trade practice. It has power to ensure no misleading advertisement is made of any goods or services. The central authority has power to ensure no person taking part in publication of misleading advertisements. In order to facilitate these powers, the central authority may do the following as per section 18 subsection 2. The central authority may inquire or investigate either suo motu or on a complaint received or on the directions from the central government, or filing complaints before district commission or state commission or national commission, or intervening in any proceeding before the commissions, or reviewing the matter and recommending the matter to the appropriate remedial measures, or recommending adoption of international covenants and best international practices, and undertaking and promoting research in the field of consumer rights, and spreading and promoting awareness on consumer rights, and encouraging NGOs to protect consumer rights, and mandating the use of unique and universal good identifiers to prevent unfair trade practice, and issuing safety notice to alert the consumers, and advising ministries and departments of state and central government for consumer welfare measures, and issuing guidelines to prevent unfair trade practices. As per section 19, the central authority has power to refer the matter either for investigation or to any other regulator. As per section 21, the central authority, on the basis of investigation, if it is satisfied that the advertisement is false or misleading advertisement and that advertisement is prejudicial to consumer interest, may issue directions to discontinue or modify the advertisement. What is the penalty for the defaulters? First, to the manufacturer or to the endorser, the penalty amount for misleading advertisement is up to 10 lakh rupees. For the subsequent contravention, is up to 50 lakh rupees, and then prohibiting the endorser for a period of up to 1 year from making endorsement of any product for the subsequent contravention up to 3 years. In case of any other person who is found to publish or party to publish misleading advertisement, the penalty amount is up to 10 lakh rupees. While determining the penalty, the central authority will consider the following grounds as per section 21, subsection 7. First, the population and area affected by such offence, then frequency and duration of such offence, then vulnerability of the class of persons likely to be adversely affected by such offence, or gross revenue from the sales earned by such offence. Right, the person is aggrieved by the order of the central authority. What is the recourse mechanism available to him? Yes, he has the recourse mechanism. He can prefer an appeal as per section 24. By virtue of section 24, the person aggrieved by any order passed by the central authority under section 20 and 21 may prefer an appeal to the National Commission. And what is the limitation period? The limitation period is to prefer an appeal to the National Commission is 30 days from the date of receipt of order. Next, my focus will be on Consumer Dispute Redressal Commission. When a consumer purchases a commodity or is provided a service and the same has some defects, then the consumer incurs a loss or injury due to the defective goods or defective services. For illustration, consumer A buys a car. The seller did not disclose the defects in the car and it was sold to the consumer in a deceptive method. While driving the car, the consumer A meets with an accident. This accident causes to amputate an organ of his body. At this stage, the consumer A suffers physically as well as mentally. Consumer Protection Act 2019 provides redressal mechanism for the loss or injury to the consumer. Yes, consumer has right to seek redressal for his loss or injury. The Act provides three-tier Consumer Dispute Redressal Commission. They are, first, in the district level, by virtue of section 28, District Consumer Dispute Redressal Commission, which is also known as District Commission, is established. State Consumer Dispute Redressal Commission, which is also known as State Commission, is established under section 42 in state level. Then National Consumer Dispute Redressal Commission, which is also known as National Commission, is established by virtue of section 53. So now we are talking about the Consumer Dispute Redressal Commission. Consumer dispute, consumer dispute, consumer dispute. What is consumer dispute? Section 2 clause 8 defines what is consumer dispute. Consumer dispute means a dispute where a person against whom a complaint has been made denies or disputes the allegations contained in the complaint. What are all the pecuniary and territorial jurisdiction for the District Commission, State Commission, and National Commission? Section 34, Section 47, and Section 58 correspondingly covering the District Commission, State Commission, and National Commission. First, we will see what is the pecuniary jurisdiction for District Commission. The pecuniary jurisdiction for District Commission, as per Section 34, is value of the goods or services paid as consideration is up to 1 crore rupees. The pecuniary jurisdiction of State Commission by virtue of Section 47 is value of goods or service from 1 crore rupees to 10 crore rupees, or value of goods or services paid as consideration in unfair contracts is up to 10 crore rupees, or appeals against order of District Commission within the state. Then what is the pecuniary jurisdiction of National Commission? By virtue of Section 58, the National Commission has the pecuniary jurisdiction for the value of goods or services is more than 10 crore rupees, or the value of goods or services is more than 10 crore rupees in unfair contract, or appeals against the order of State Commission, or appeals against the orders of central authority. Then what is the territorial jurisdiction? The same sections are covering the territorial jurisdictions also. For the District Commission, the territorial jurisdiction is the place of opposite party or opposite parties who is residing or doing the business, or the place of opposite party who is residing or doing the business at the time of institution of business, or place where the cause of action arises wholly or partly, or the residence or workplace of the complainant. What is the territorial jurisdiction of State Commission? The State Commission has territorial jurisdiction with respect to the place of opposite party where he or they ordinarily residing or doing business, or place of opposite party residing or doing business at the time of institution of business, or place where the cause of action arises wholly or partly, or place of complainant where he or she resides or working. For the National Commission, the territorial jurisdiction is pan-India. Right. Who can file a complaint? The complaint can be filed by consumer or recognized consumer association or central government or state government or central authority. By virtue of section 35, the consumer or recognized consumer association or central government or state government or central authority can file a complaint before the district commission and before state commission by virtue of section 49 and before national commission by virtue of section 59. Next, what is the limitation period of admissibility of complaint? Admissibility of complaint shall be decided within 21 days. If it is not decided within 21 days, then the complaint has been admitted. It has to be deemed as it is admitted. In case of rejection of complaint, the opportunity of being heard to be given. In case there is an element of settlement, then the commission may refer to mediation. If commission opines that there is an element of settlement which is acceptable to the parties, may direct the parties for mediation. And if the parties agree for the settlement by mediation, shall give their consent in writing within 5 days on receipt of the direction. This reference to mediation is covered under section 37 for district commission and section 49 for state commission and section 59 for national commission. Next, what are all the procedures to identify the defects? First, we can bifurcate the consumer disputes into two categories. First, defects in goods. The second one is defects in services. When the allegation or the complaint is regarding the defects in goods, then the commission will obtain the sample from the complainant. Then it will send to authenticate lab or proper analysis or test to identify whether such goods suffer from defects alleged in a complaint, and then directing the lab to give the report within 45 days. If any of the parties dispute the findings or methods for test which was adopted, can submit the objections in writing and then giving reasonable opportunity to be heard to both the parties. Right. In case of defective services, on the basis of evidence brought to the commission's notice by both the parties, or ex parte on basis of evidence brought by complainant if opposite party fails to represent, or deciding the complaint on merits if the complainant fails to appear on the date of hearing. Now the procedures are very detailed, planned in the section 38, and the section 38 is applicable to state commission and national commission by virtue of section 49 and 59 correspondingly. So after the admission of the complaint, the commission shall refer the copy of admitted complaint to the opposite party within 21 days to get the version of opposite party. Opposite party shall give his version in 30 days, but the commission can extend the days up to 15 days after 30 days of period. If the opposite party fails to give his version or denies, the commission shall proceed to settle the dispute in such a manner to identify the defects in goods or services as we discussed here before. Every complaint shall be heard based on affidavit and documentary evidence. Every complaint shall be disposed of as expeditiously as possible. The commission may pass interim order as is just and proper during the pendency and proceedings. What are all the powers of commissions as per section 38, 49 and 59? The commission has power to summon and enforce the attendance of defendant and witness, recover the discovery and production of any document or material object as evidence, receiving of evidence on affidavits, demanding the report of analysis or test from appropriate lab or relevant source, issuing of commissions for examination of any witness or documents, any other material which may be prescribed by the central government. Right. The commission has identified some defects in the goods or services. What will be the next step by the commission? Section 39 gives a detailed analysis of what are all the next procedures, steps to be taken by the commission. The commission shall order to remove the defect or to replace the goods with new goods or to return the price to the complainant, or to pay compensation amount to the consumer for any loss or injury suffered by the consumer, plus punitive damages if needed, or to pay amount as compensation in product liability action, or to remove the deficiency in service, or to discontinue unfair trade practice and not to repeat, or not to offer unsafe or hazardous goods and to desist from offering hazardous services, or to pay such sum for the loss or injury by large number of consumers who are not identifiable conveniently, that some amount minimum has to be 25% of the value of defective goods or defective services, or to issue corrective advertisement in the case of misleading advertisement, or to provide adequate cost to the parties, or to cease and desist from issuing misleading advertisements. Section 49 and 59 is covering all these things for State Commission and National Commission. Apart from these steps, the State Commission and National Commissions have some more procedures. These are applicable only to State Commission and National Commission. Section 49, State Commission may declare unfair contract or unfair terms in a contract to be null and void, and the State Commission shall have power to review its orders which have error on its own or by the application of parties within 30 days. And as per Section 59, the National Commission may declare unfair contract or unfair terms in contract to be null and void. The National Commission shall have power to review its order by virtue of Section 60 and to set aside expiry orders by virtue of Section 61. What is the recourse mechanism? Again, here also, there is the provision of appeal against the order of District Commission, against the order of State Commission, and against the order of National Commission. Section 41, Section 51, and Section 67 deal with the appeal against the order of District Commission, State Commission, and National Commission correspondingly. When a party aggrieved by an order of District Commission may prefer an appeal to State Commission within 45 days, the appeal has to be on the ground of the facts or ground of the law. Delay in appeal can be controlled by the State Commission on reasonable ground. As per Section 51, the party aggrieved by an order of the State Commission may prefer an appeal to National Commission within 30 days, and National Commission can condone the delay of appeal on reasonable ground, and the appeal shall be heard as expeditiously as possible. Then the party aggrieved by the order of National Commission may prefer an appeal to the Supreme Court within 30 days. The Supreme Court can condone the delay of appeal on reasonable grounds. In case no appeal is preferred on the order of District Commission or State Commission or National Commission, such order shall be final by virtue of Section 68. What is the limitation period of filing the complaint? Section 69 gives a limitation period, maximum 2 years after the cause of action arises. The Commission can condone the delay on the reasonable ground. And how to enforce the orders? By virtue of Section 71, every order of the Commissions shall be as enforced as the degree of the court in a suit. What is the penalty for non-compliance of orders? Either imprisonment, minimum 1 month to maximum 3 years, or fine, amount rupees 25,000 rupees to maximum 1 lakh rupees, or both. This is by virtue of Section 72. There is a poem in Tamil, Kana Mailada Kandirantha Vankuri, Tanu Madhuvaka Bhavitha, and Kalla Sarada Viritadina Kunumu, Kallada Pachatu. That means, as an ostrich, on seeing the dance of a peacock with beautiful plumage, also tries to dance. So, an illiterate person composes poems on seeing the excellent verses of the learned poets. My presentation might also be like that in this noble learned assembly. Thank you all for listening to me and to my presentation very patiently. I express my sincere thanks to the School of Excellence in Law, the Tamil Nadu Dr. Ambedkar University, Vice Chancellor Sir, and PhD Director Haritana, under whose guidance I am pursuing my PhD now, and Registrar Ranjit Sir, my dissertation guiding my LLM, and all my teaching faculties, senior colleagues, and other panel members for having given me the opportunity of being one of the panel members in this discussion. And thank you all.
Thank you, sir, for the educative information. Our next panelist, Mr. Meyyappan Kumar, sir, Faculty of Law in the Tamil Nadu Dr. Ambedkar Law University, School of Excellence in Law. And sir has completed his Masters in Business Law and also in Business Administration and also in Economics and Public Administration. I invite sir to discuss about product liability. Welcome, sir.
Yeah, good morning to one and all. Am I visible and audible?
Yes, sir.
Okay. So, I'll just continue with this presentation. So the next topic which we'll be looking at is with reference to product liability. So we have just got an understanding about the introduction to Consumer Protection Act and the 2019 Act. And the next we have also seen, now we will be looking at product liability as such. So when you look at a product liability or a liability in law, it is a responsibility bestowed upon the particular manufacturer by virtue of law. So here, when we look at product liability, the mention to this regard was not there in the previous Consumer Protection Act 1986, which is found now in the Consumer Protection Act of 2019. So it is relatively a newer concept called product liability, which is set in motion by the new law, that is the Consumer Protection Act of 2019, whereby it allows these aggrieved consumers to claim significant compensation as a remedy from before a court of law for any defective product that they have been supplied with or any deficiency in service that they may have come across. So when we look at the 1986 Act, I just said that there was no provision, but when we look at the 2019 Consumer Protection Act, we have a provision as in the chapter 6, which goes from sections 82 till 87. So chapter 6, sections 82 till 87 deal with product liability. So it tells us, or it tells us that for a claim for product liability, it can be made against a manufacturer, that is the person who produces the product, or a service provider, if at all it is for a service that has been rendered to us, or for both of these people to compensate us if there is any loss caused to the consumer, that is us, by way of these deficient products or deficiency in services. So when we go buy a product and we are unhappy with what we have got, then we can return it back and they need to compensate us. Or if we have got a service and we're unhappy with the way the service is being given to us or rendered to us, we can claim for deficiency in services. So this particular act, the new Consumer Protection Act of 2019, has brought about this concept of product liability, thereby making the manufacturer or the service provider liable if at all they supply us with these defective products. When we look at e-commerce, as it has already been discussed, electronic commerce is using the latest technologies. So nowadays we prefer electronic commerce over going to retail stores and purchasing it. So when we speak about electronic commerce, even that is brought under the purview of product liability. So say we buy something online and still we are not happy with the product that has been delivered to us, or we are unhappy with the service being rendered to us, yet we can bring even e-commerce platforms under this particular product liability provision. The relevant provision to bring an e-commerce under product liability is section 39 subsection 1 of this Consumer Protection Act 2019. So the basics to understand is product liability, a responsibility of the manufacturer for manufacturing and giving us a product. It should be in a proper quality as expected. If it is not so, or if it is defective, then yes, he is liable to replace the entire product and give it to us along with some compensation as we may claim. Now, when we look at section 2, generally talks about the definition provisions. When we look at section 2, subsection 6, subclause 6 of the Consumer Protection Act 2019, it provides that a claim may lie, that is a product liability action. This claim is called a product liability action. It may lie against a product manufacturer, a seller, that is the person, a retailer we can understand, who is selling that product, and the product service provider as such. So three people, we can make them liable: the manufacturer, seller, and the product service provider. Next is when we look at section 2, subsection 34 of this particular act. When I say the particular act, we are referring to the Consumer Protection Act 2019. It speaks of compensation to be provided to the consumers. So compensation, say we have got a service, that is we have received a service and it is deficient in nature and we are unhappy with the service or the product is defective, we can claim compensation as a remedy for the defective service that has been rendered to us. When we look at section 2, subsection 35, it deals or discusses with product liability action. So where you could file the complaint, just now we saw the procedural aspects. It could be filed before the district or state or the national commission. And when we look at 39.1, section 39, subsection 1, it says that the damaged goods should be replaced with the new goods of the same thing, same kind that you have already paid money and bought. So when we look at a consumer is a person who has actually paid consideration by way of price to buy the product. So obviously he needs to have a good quality of product, or at least the basic quality that has been assured. If at all that is not there and the product is defective, yes, then he can go forward and make a claim to replace the product, also to claim compensation under the relevant provisions in this particular act. Now, when we look at product liability and the relevant legal provisions as such, we refer chapter 6, sections 82 till 87 of this particular act. So when we look at 82, it says that we can have a claim can lie for the whatever I just mentioned, against a manufacturer, against a seller, and also against the retailer who is giving it to us. The next one is when we look at section 83, it talks about product liability claim. So the claim can be brought by the complainant. So the complainant here is generally the consumer, that is us. When we purchase a product or avail a service and are unhappy with that, we can file a complaint before the commissions, which I just said. So it can be brought about by the complainant against the product manufacturer or the product service provider or the product seller. So the three are different parties. So as we know, the manufacturer manufactures the product and the seller sells the product, and the service provider is the one who's giving us a service. So say we take for example, a product, say we purchase a car, or we purchase anything, a product as such, or a service. We take out an insurance policy, that is a service that we are getting. Or we are a communication, we're a consumer in the telecom industry. Say we have a mobile connection through Airtel or any other telecom company. There we avail their services. After availing the same, if we are unhappy with that, we could always claim for compensation or ask them to provide services as prescribed. Okay, so all this can be found in provision 83, which talks about product liability claim. Buying a product, unhappy with that, then yes, we can ask for a compensation for the harm. That is, the harm is the defect that has been caused due to the defective product as such. When you look at the next provision, that is 84, it says the manufacturer is liable for defects. What all defects he is liable for is a manufacturing defect, a defect in the design, or deviation from specifications. Say there is a particular specification in which he has to produce a product or manufacture the product, and he has not done in that manner, then it would become an inherent defect and he is liable to compensate the particular person who has bought it. Also, if it does not conform to express warranty, say the express warranty conditions are given, say a period of 1 or 2 years is given as product warranty, and within that period, again, if the product does not function properly, the manufacturer has to compensate us with a new product of the same quality. So all these are certain things that are found in section 84 as to when all the manufacturer is liable if at all he is giving us a defective product. So he is liable if at all there is a defect in manufacturing the product itself, or there is a defect in the design, or there is any deviation from the specifications as given, or it does not conform with express warranty that has been given by the manufacturer. So just to assure product assurance or quality assurance, the manufacturers generally give us warranty. So say the product does not function well within that period of warranty, we can obviously make a claim. So that is given. So there are a few cases also that have been given or discussed, or the judgments have been given by the court, where they have just said that compensation can be arrived based on the facts and evidences that have been adduced before the courts of law by the complainant. So the one who is actually making the complaint has to prove that yes, it is being given a defective product, or the service that has been rendered to him is deficient in nature. Next is when we look at the next provision, section 85. It talks about product service provider being liable. So here, where the service provider as such is being liable. First one is when there is a deficiency in service provided by him. Say we take an insurance company, for instance, and we get a policy with them, and we are not happy with the way they are servicing the policy. As in, when we make a claim, they're not honoring the claim, or if we are asking them something and they're not answering us properly, then that is a deficiency in service that is being provided by the particular company. So under section 85, we can bring them, or we can make them liable. That is product service provider being liable. Or when you look at the next one, for what else they will be liable? For omission or negligence or willful withholding of information, which they should have told the consumers, but they failed to say. If this is the case, yes, again they will be liable. And also the service providers will be liable if at all they have to issue warnings as to use the product. So when we see product wrappers, they'll be giving some warnings as to use. So if they're not mentioning that clearly, then still they will be made liable. Next is when we look at the next provision, section 86 talks about the product seller being, the product seller not being liable. Okay, so when all he will not be liable is, suppose he has a control over the design, testing, packaging or labeling, and this is when a seller is liable and not a manufacturer. So when the seller himself is making the design, say the manufacturer is giving us with a cover or a design and the seller is making some addition to it, and in that addition which he is making, there is something that causes the harm to the buyer, then the seller will be liable at this juncture and not the manufacturer. This is given under section 86. So next is when we look at the last provision, section 87, it generally talks about the exceptions to product liability. As in, we have just seen when all they will be liable. Now this provision just talks about the exceptions as to when the manufacturer or the seller is not going to be liable. So say they have specified a certain way to use the product and we as a consumer are not following that, or we are not using the product in that manner, then yes, they will not be liable. So they have given the directions as to use, and say we are not using it as per those directions, and thereby or thereafter we suffer a loss, then you could not go make a claim for that in that manner. Or prima facie, on evident of using, just by looking at it, we understand that we need to use the machinery carefully, and we're exercising due care while using the machinery, and therefore we suffer some kind of damage, then yes, the product manufacturer or the seller cannot be liable in that case. The person who has bought it has not exercised due care in using the product. But otherwise, generally, if the product is defective or the service is defective in nature, is deficient in nature, then the manufacturer or the seller or the service provider likewise are liable for the same. So when we look at product liability, chapter 6, this act has this much to say. And the previous presentation we just saw regarding how to make a claim in case we have a defective product. So this is with reference to my presentation. I thank Tamil Nadu Ambedkar Law University for giving me this opportunity to present it. So thank you one and all.
Thank you, sir, for sharing your expertise. Our next panelist is Mr. Inva Vijayan. Sir is a faculty of law in School of Excellence in Law. Is accredited as an arbitrator in leading international and regional arbitration institutions. He has presided as a sole arbitrator and presented as counsel in over 300 domestic cases, several small claim commercial arbitrations, and 14 international arbitration. His expertise in various fields of law that includes international commercial arbitration, maritime arbitration, international trade and contracts, intellectual property rights, and also construction disputes. To add up, he is a co-founder and former secretary of an arbitration institution, CNICA, and inducted as member of ICCA. I invite sir to discuss with regards to mediation. Welcome, sir.
Thank you. Thank you, Mr. Vignesh. Good morning or good afternoon to all, one and all. It is a great privilege, as rightly Dr. Ranjit Oman Abraham, the registrar in charge, was mentioning, our institution, KFCRI, joining hands with Dr. Ambedkar, Tamil Nadu Dr. Ambedkar Law University, and deliberating on this particular aspect on the consumers on the International Consumer Day. Thank you. Thank you for the opportunity given to me. And I like to thank all the administrators and the faculties, including particularly Dr. Ranjit Oman Abraham, Dr. Bhuvaneshwari ma'am, and Dr. Redivadi Shri ma'am, as well as Aarti ma'am, for giving this opportunity to share about a software version. We can say it's a software, not a hardware in consumer. The software, what we are going to use is the mediation. Having said that, there was a great shift in dispute resolution. I think many are aware, and already the earlier three speakers were highlighting about the salient features of this Consumer Protection Act, both the 1986 and the present one of the 2019. The very common issue which we can come across in the time panel is that ultimately what is going to be the remedy given to the aggrieved party. The aggrieved party has to see the end, or they have to be successful, or even they are going to lose, at least there should be an end in any dispute resolution process. This was not happening. The very spirit of the Consumer Protection Act 1986, it was clearly laid down that it has to be within a time-specific resolution process, but it didn't happen in any of these forums, whether it is the district forum or the state forums or the national forum. It had its own sweet time to be resolved. As looking into this, we need to have an improvement. The improvement has been brought in. I think the sections running from 74 to 81 of the Consumer Protection Act 2019, which is dealing with mediation, particularly introduction of mediation in consumer disputes, is really a game changer. And the good thing is that before enactment of this 2019 major amendments or the repeal to the earlier act, there was a notion that consumer disputes cannot be taken to ADR, that is alternative dispute resolution. Countries like US and UK, they were doing consumer arbitrations as well as consumer mediation. But in India, we had a concept called the non-arbitrability and non-possibility of taking these disputes to any of these ADR mechanisms. That was the situation quite early before 2019. And the another legislation, which is the section 89 of the Civil Procedure Code 2000 and the 2002, wherein it came into effect, also specified generally about the judicial authority referring the matters to mediations or conciliations or arbitration. When it comes to a special statute, that to a Consumer Protection Act, the original one, 1986, there was some restriction, and if a party comes within the definition of the term consumer, then literally that dispute has to be taken only before the forums created by the district or the state or the national. That was the situation. Now we need to have a change. That change has given an opportunity to one of the ADR mechanisms, not all the ADR mechanisms. Still now, consumer disputes cannot be taken to arbitration. Consumer disputes cannot be taken to even conciliation. Now, the consumer disputes can be taken to mediation by way of reference. Reference can be done by the district, by the state, as well as the national consumer forums, wherein this is now possible. Okay, getting back, what is the situation, actual situation, what is the purpose for it? The growing number of pending cases in consumer courts, obviously there were delays in getting redressal. It has to be addressed with some fast track alternatives. That is a very keen objective. We need to have a fast track, that is less time consuming process, wherein the solution should be given to the parties. And this, when it comes to consumers also, it's quite urgent, imminent, and it has to be brought in. And that happens to be one interesting background for bringing in the 2019, particularly including mediation. There were huge challenges also faced by online buyers. Everyone using the online platform, that too for the past 2 years, we are using more constructively all the online platforms. The breaches like data privacy, securities, substandards, duplicate products, phishing, as well as the territorial jurisdiction, much were hitting the nose of the various departments which are dealing with these subject issues. In our legal system, the appropriate methods of dispute resolution, such as the arbitrations, conciliations, to some extent lok adalat, can be used easily in consumer dispute also. And these methods are quite considered to be not too much formal and not informal also in total. Encourages disputants to communicate, that is very important, and participate in the search of solutions, focusing better on the root causes of the conflict, as well as salvage a relationship and have significant savings in the time and cost. There are some interesting points which has to be kept into consideration when any dispute has to be resolved. Considering the consumer disputes, that also matters. But we need to have a process which has some legal backing. That legal backing now we have with, probably we are going to have with the Mediation Bill 2021. I think it might be somewhat a value addition, which might be beyond the scope of this particular seminar, but still a Mediation Bill 2021, which is in the anvil of likely to be passed. This bill is going to be creating a new opportunity wherein the legal backing is going to be there for mediation. In 2019, when it was included in the Consumer Protection Act, we didn't have a proper law for mediation. Now we are going to have Mediation Act, which is going to guide the entire dispute resolution, not only the process, but also enforcement. That is very important. We all are very keen to have a process which is likely to be final as well as binding. That is going to be evident by creation of this mediation bill. Okay. Getting back to this, the particular necessity for having mediation in consumer cases. Even though this concept of mediation is an ancient, deep-rooted in our country, we did have a lot of systems like the Panch used to be called the Panch Parmeshwar, which is equated to God. A lot of traditional, the community-oriented, the society-oriented mechanisms were there, which we normally call as the NSJS, non-state justice system, which didn't have the legal backing. We did have the practice, but many times consumers are wary of approaching the consumer forums or the civil courts for the decisions of the disputes. They were not keen to deal with these type of the traditional system which is coming under the NSJS. Mediation in comparison to a lawsuit, which is quite quick, private, fair enough, and to some extent inexpensive. And this bill or the Act 2019 also gives a cost-effective process. And in this different paradigm and path from litigation, we are focusing to be facilitating towards the ADR mechanism, which going to have an informal procedure, a reasonable level of informal procedure, and the outcome is likely to be enforceable. If you see in Western jurisdictions, the response to mediation is very successful. The Court of Law also facilitates the court annex mediation, which now in India also we do have because of the Section 89. We have the court referred mediation. In Tamil Nadu, we have this Tamil Nadu Mediation Conciliation Center, which is to the far extent providing the services in an acceptable manner. And all the court referred mediations are literally successful. We can say it is really successful, and we are getting the constructive outcome. And this constructive outcome now we need to also have it in the consumer domain. And this mediator or the mediation process is likely to be brought in. And along with that, we also need to have this online consumer mediations also. That is the objective of it. And now we have this Mediation Act. If you see a prominent judgment, it is the SpiceJet Limited versus Ranju Array. The consumer had to fight its case from the district forum to the state forum and to the national forum, and then finally to the apex court, the Honorable Supreme Court, regarding the contract of services which they entered through internet and the cause of action of the complainant. All these were dealt from the court of first instance, at least in the consumer forum. It is the district, state, national, and ultimately the apex court. This order of adjudication might need to have some alternative. In order to accelerate this process of adjudication, mainly out of this particular case, we are having this Consumer Protection Act 2019, which envisaged the establishment of the Central Consumer Protection Authority, mediation, the product liability, and faster redressal by the consumer commissions. This This inclusion of the various provisions like section 74 to 81 in the Consumer Protection Act, quite interesting. And we also, there is an opportunity to create some rules. And now we have the 2020 rules, which is the regulations, which is downlining how a mediator has to be appointed, what type of training the mediator has to be given, how the mediation has to be conducted, where the mediation has to be conducted, what might be the cost for the mediation. All these they are trying to give in the rules. But focusing the act, the Consumer Protection Act, section 74, we do have an interesting part, that creation of a mediation cell. The state government would establish a consumer mediation cell, which would be attached to the consumer forums or the redressal forums, and each of the regional benches also would be located. Every consumer mediation cell would submit a quarterly report to the district commissions, the state commissions, as well as the national commissions. And the very interesting task of this consumer mediation cell would be on the listing of empaneled mediators, a list of cases handled by the cell, a record of proceedings, that is like acting as a depository, and any other informations as may be specified by the regulations in the coming years or months. Here, the important point is that the listing of empaneled mediators, who are going to be the mediators, and what training the mediators should have or should undergo to become a mediator. Here, the regulations have gone to extreme level, wherein they wanted to have the mediators chosen by the mediation cell to have a 40 hours mediation training. A 40 hours mediation training is going to mold with a lot of simulations. The exercises, or like normally students have the aspirations of participating in competitions in moot courts. Likewise, simulation is very much necessary for a person who are likely to be appointed as a mediator before being enlisted in the empaneled mediators. Such type of deliberations have been facilitated by this particular act, as well as the regulations, the rules 2020. This tenure of the panel of mediators would be to a valid period of 5 years. It is like a long period wherein they can be in the panel, and these empaneled mediators shall be eligible to be considered for re-empanelment for another term. Another term means it can be another 5 years. 5 plus 5, 10 years, subject to the conditions as may be specified by the regulations in a regular interval. This mediation component shall be held in the consumer mediation cell, which is likely to be created and would function attached to various consumer courts, and that is being facilitated by the subsequent provision, that is clause of the section 75. Moving on to the 76 to other 80, we also have or it provides that it is a duty of the mediators to disclose certain facts which may likely to give rise to justifiable doubts as to his independence or impartiality. It is somewhat similar to the provisions subsequently which has been given in mediation bill, as well as which has been taken from the Arbitration Conciliation Act, which also speaks the traditional term which was used for mediation in a country, that is conciliation. A mediator is not as such appointed with his expertise in the domain, that is the consumer domain, or his experience or his exposure in the mediation process. It is very important that that mediator has to be independent. An independent person having the quality of giving a process or facilitating a process with impartiality and unbiased nature is very important. And section 76 emphasized that by the mediator giving a disclosure in writing is very important, and it's good that it has been included in the 2019 regulations. Moving on, looking into section 78, which provides for replacement of mediators. Then we have the provisions relating to settlement through mediation and what is the role of the mediator when an agreement is reached between the parties with respect to all of the issues involved in the consumer disputes. It is somewhat similar to how it has been structured in the conciliation provisions in the Arbitration Conciliation Act, that is from section 61 to 81, which has been covered in the Arbitration Conciliation Act. A summarized version has been brought in this Consumer Protection Act 2019. But anyway, it is good. This particular inclusion has its own advantage as well as disadvantages. But having said that, we are very particular about the growing backlog and delay in the resolution of consumer disputes, and it is also eroding the consumer trust in the legal system, where it is very, very important for us to find a solution. Now we have this mediation can play an important role in consumer dispute resolution, especially you can see the cases which are pending for more than 5 years or even sometimes a decade in consumer courts, and we have the best possibility of resolving this particular dispute in mediation within a time which is likely to be what you can say 3 months. And reading along with the mediation bill is very important. We have to just seriously consider the mediation bill also. The mediation bill is going to give an opportunity for 3 months, and further extension can also be given another 3 months. Totally 6 months is possible. But here it's the task for referring the matter to mediation is a task given to the referral judge, and that referral judge is an interesting person. That is a consumer forum presiding officer. He is going to refer the matter to mediation. This appointment of mediator from the panel as well as initiation of the mediation proceedings, these are all good and a constructive development in this amendment, the 2019, which is being brought in. But still, we do have some aspects which has to be addressed. Like in the mediation also, we do have some problem. Example, if a consumer knocks the doors of the court after he has already exhausted other alternative remedies, for instance, complaint of a defective product or one availing insurance services, the first approach that the product provider, the service provider, or the complaint cell of that provider and tries to settle the issue. And if that fails, a complaint is filed with the consumer forum. However, with the introduction of this mediation process, an additional step is introduced which can prove to be time consuming. That might also arise. And further, if you see, if there has been no agreement between the parties within 3 months, very important, the agreement, what I'm mentioning here is a settlement, an amicable settlement, which is not happening within 3 months, the consumer would have no option but continue with the normal regular proceedings. This might escalate the pendency of proceeding. This is one negativity what we can see. But still, if it is a successful settlement is arrived within the 3 months, therein is the issue. But if there is no success, a successful amicable settlement is arrived, then we have to continue with the regular proceedings. Likewise, we have a lack of bargaining power. In mediation, often it is synonymous to like a compromise where the parties mutually come to an agreement. However, we can see mediation can often be problematic where one party, usually the consumer, might have less bargaining power. For example, if you can see a typical case of delayed possession of flat, buyers might have to settle for such less than what the court grants. These are some issues when it comes to bargaining power. Lack of bargaining power also is evident in the mediation process. Moving on, there are some suggestive nature. What a mediator normally in mediation, the decision of mediation or the mediator is only suggestive. And the mediator has two important tasks. One, he has to facilitate and another he has to evaluate. And the mediator is not going to draft that particular settlement agreement. The mediator are just going to facilitate what a settlement is going to be arrived from the parties, and this settlement is likely to be recorded by the mediator under the instruction of those parties. In that way, it might also be quite a complicated one in this particular process. We can just add on multiple aspects, and there might be some judicial interventions in this process. The party autonomy, to what extent it is safeguarded. We are going for these alternative dispute resolution only for to have the parties right to decide and resolve the disputes. Instead of the third person deciding, the parties are being facilitated to come to a settlement. Here, one interesting personal experience what I had before the pandemic, I think the month of February 2020, I was there under the invitation of Government of West Bengal, based on this 2019 Consumer Protection Act. They are planning to bring down mediators from the Department of Consumer Affairs itself. If you are going to have the officials of the Consumer Affairs Department of any state or the center, they are going to act as a mediator. Imagine to what extent the party's autonomy would be there. The officials are going to sit as mediators. These are some challenging things what we have to look upon. And when we are going to literally have a constructive mediation with the help of the mediation bill, that is the 2021 bill, that is going to be a real eye-opener, and the very spirit of inclusion of this particular mediation in section 74 to 81 is going to have a fruitful outcome, and hope all the members here participating as well as the institution as such would have a clear say on this mediation process, and the mediation process to be a successful process in resolving consumer dispute has to be evident by all stakeholders, that is the future lawyers who are going to represent the parties. Thank you.
Thank you, sir, for sharing your expertise and elaborating mediation process in an interesting manner. It was very informative. Thank you, sir. Our next panelist is Mrs. Aarti Ratna ma'am, Assistant Professor, SOEL. Ma'am has presented and published the article in various national and international level, and has organized workshop, symposium, and webinars in our university. I request ma'am to discuss about celebrity endorsement. Welcome, ma'am.
Thank you, Vignesh. Good morning, one and all present here. My area of discussion is legal regulations of celebrity endorsements. The word celebrity endorsement generally means a form of brand or advertising campaign that involves a well-known person using their fame to help or to promote a product or service. The producer or the manufacturer tries to reach the consumer quickly through the goodwill already gained by the celebrity. The consumer is attracted towards a product as it is endorsed by the very own person whom they adore, whom they like a lot. Why do we need the celebrity endorsement? Why people go for it? Why the manufacturers, why the sellers go for celebrity endorsement? So using a celebrity in advertising causes to influence brand attitude and purchase intentions of consumers in the positive way. When celebrity appears on an advertisement, either through newspapers or electronic media, to advertise a product or service, they immediately catch the attention of the consumer. So the influence will be stronger if the celebrity endorses the same product or service for a longer period, and if he consumes also. So the celebrity endorsement strongly affects the consumer's memory and their learning approach. This is because of the instant recall factor that ensures immediate focus on the brand. In India, television is most popular and effective means of mass communication. There are over 3 million television commercials being aired every year. However, only 80% of them are successful, and 80% of them are not successful, and it is very easily forgotten by the people in a day or two. Since advertising is highly critical tool for making the consumer to make purchase, Indian firms are investing millions of rupees on celebrity advertisement. So general advertisement, which is ad, is not going that popular, but when a celebrity gets into the advertisement, it becomes really popular and it influences the people to buy. So therefore, the advertisers in India emphasize a lot on brand recall and customer persuasion for differentiating their ad campaigns from those of their counterparts. So endorsers have gradually come into categorizing like four different categories, four different groups are there. One is celebrities and well-known people, then the experts, then the consumer endorsers and organizations. On an average, the consumer in a country like India, where illiteracy still prevails, a celebrity endorsement is taken for granted and believe it to be true. So in 2015, the Consumer Protection Bill was introduced in the Parliament, which dealt with endorsers' liability expressly for the first time. But bill was withdrawn for some issues. The present Consumer Protection Act 2019 has brought in a very important provision which fixes the responsibility of a celebrity endorser. The celebrity endorsing a particular product is also liable for the product, and he may be punished if it is misleading information. Again, it is to be remembered that the goodwill of a celebrity gets automatically transferred to the product when it is endorsed by him. Hence, he has to be responsible while he is appearing in an advertisement and claiming the benefits of the product. One of the provision in this act gains much attention in today's scenario. The celebrity endorsing a particular product is also liable for the product, and he may be punished if it is a misleading information. A consumer is given more rights, and also the endorser is made responsible while endorsing a product through an advertisement under this unfair trade practices in the 2019 Act. As per this said provision, no celebrity can take a defense that he or she is ignorant of the product or its components and its impact on the consumer. But the section 21 clause 5 of 2019 Act says no endorser shall be liable to a penalty under sections 2 and 3 if he has exercised due diligence, subclause 2 and 3, if he has exercised due diligence to verify the veracity of the claims made in the advertisements regarding the product or service being endorsed by him. It states that the endorser is not liable if he has exercised due diligence, but there is no definition for due diligence or circumstances stated when he has exercised his due diligence. If it is left vague, and so it will be interpreted, it may be interpreted according to the facts and circumstances of each case. It is best known to the legislators whether it is possible for a celebrity to know about the product and its combinations and effect of it before appearing in an advertisement and endorsing it. Another aspect is that there was punishment prescribed for the celebrity for misleading advertisements in 2015 bill, but the punishment aspect is not found in the new act. So it is very easy for a celebrity to prove that he has taken all care before endorsing and what he has stated was true to best of his knowledge and escaped from the liability. So the real applicability of this provision in terms of consumer rights is still questionable. Another vagueness in this act is the word party to the publication under section 21 clause 4 of the new act. It is unclear as to whether an advertising agency who created the advertisement or the media which published it would fall under the phrase party to the publication. It is obvious that both parties who created and published are equally liable for a misleading advertisement, but it is subject to interpretation in future on case-to-case basis. On a concluding note, I would like to conclude that advertisements have a very important role in the purchase of goods. It is the gateway for the consumer to know the products in the market. It also serves as an important tool for the producers to make the product reach the consumer. So there is no doubt that advertisement acts as a connecting link between the manufacturer and the consumer. The impact of advertisement has more impact when it is featuring the celebrity. The brand value of a product gets its value increased based on the status of the celebrity. The consumer choice are often based on the confidence which he has on the celebrity. In country like India, an average consumer has trust on the words of the celebrity. So this gains more impact when the consumer happens to be children or the youngsters. The product and the quality of the product gets more attraction and or more embedded in the minds of the children when their favorite hero in the movies or a sports person endorses the product. So the responsibility of the endorser has to be more. Above stringent laws and provisions, it is the public who have to be aware of their rights and use it accordingly. The new act has given more rights to the consumer, and so it is time for the consumer to act accordingly in exercising the right. It is only when the consumer exercises right, the law gets its real meaning. Thank you so much for giving me the opportunity. I thank Vice Chancellor Sir, Dr. Ranjit Sir, and Dr. Harita Ma'am for giving me the opportunity. Thank you one and all.
Thank you, ma'am, for demonstrating us about the way celebrity liability existed under this act in a very detailed manner. Thank you, ma'am. Our next panelist, Mrs. C.R. Aishwarya, Assistant Professor in School of Excellence in Law, having started her teaching career in the year 2015. She completed her LLB from Padmavati Mahila Vidyashalam, Tirupati, and was awarded gold medal for securing first rank. And she completed her LLM from National Law School of India University in Bangalore. In her 5 years of experience, she expertised in various fields of law, and she published and presented in national and international journals and seminars. I invite ma'am to discuss about consumer awareness. Welcome, ma'am.
Thank you, Mr. Vignesh. Uh, just a second, I'll see if my PPT is shared. Is my PPT visible? Is the screen visible? Thank you, ma'am. So yes, I'm the last speaker in this panel discussion today. After almost 2 hours of discussion, elaborate discussion on Consumer Protection Act and the rights provided under the Act, enforcement mechanism, I have indeed a little left to talk about. I have chosen to speak about consumer awareness today, and we know that the efforts which is being taken by the government by bringing up this legislation, updating it, amending it, including so many provisions to make sure that the consumers' rights and interest is protected. Not just the Consumer Protection Act, along with it, we do have many more legislations wherein it helps us to ensure that there is a fair market, fair competition in the market, and consumers' interests are protected. In spite of that, if we see the plight of consumers are still not is not quite impressive. The reason is not that we do not have legislations in hand, but then it is that the consumers lack awareness about it. They are not aware about the rights which they have, or the protection which is being extended by the government, or the efforts which is being taken by the government. And at this instance, I feel that consumer awareness or spreading consumer awareness will be a key role, will have a key role in achieving the object set under the Consumer Protection Act. Just a second, yes. So now, not just that, the government has also taken initiative and has set up this Department of Consumer Affairs specifically to focus on these key areas. And in the year 2002, in the 50th National Development Council meeting, it has assigned the task of evolving a national action plan for consumer awareness and redressal and enforcement of Consumer Protection Act of 1986 to the Department of Consumer Affairs. Eventually, hundreds of crores of rupees is being spent with the only to educate consumers. Until now, over 100 crores of consumers are already educated by creating awareness in various fields and in different subject matters related to them. That being on one hand, wherein the government is taking efforts and then spending so much of rupees, coming up with an action plan, that's on one hand. On the other hand, what should the consumer do? The act provides, or the act gives him rights, but then along with this rights, or this right should be complemented with certain responsibilities of a consumer. So this session, in the book which we have published, ends with a note to the consumers wherein certain tips are given to the consumer. We'll talk about it. The first tip is that quality of the product. Now, as a consumer, so all the people, when they make a decision to buy certain goods or services, they'll have to make sure that they have enough information, or information about the goods which they are going to buy or the services which they are going to avail. At that point itself, they could avoid being cheated or deceived by the sellers or service providers. The second point is dealing with advertisements. Now, we want it or not, it is become a practice that with the number of advertisements, as Aarti ma'am rightly spoke, it's more influential. Even without our own knowledge, we'll get influenced by the advertisements. And most of the times, the fact remains that advertisements do not portray the true picture, but selective information, whatever is in favor of them, that okay, so that alone will be showcased. At that point of time, as a consumer, we'll have to take a bit more effort and then make sure that we are not caught under that under the practices which are adopted by the sellers and producers. The next type is even smaller one. It might look like a petty tip, but then it goes a long way. Before buying a product or service, a consumer will have to check manufacturing date and the date of expiry. This might not give any guarantee as to the quality or the safety of the product, but then it would definitely provide us information as to when is it produced, or till how long will it potentially be safe to consume such products or services. So that ways it would be helpful. And the next is purchase of standardized goods. So all right, this is even more easier. We know that there are certification marks which are being awarded by proper agencies, wherein only after you comply with certain standards as to the qualities, such marks would be granted. So now, instead of me trying to, as a consumer, I trying to find out information, if I try to look for such a mark on a product, then that itself is enough. For instance, silk mark, or for instance, UG mark, or all these things, ISI mark, when I find that, that's enough. It assures that the product being sold or the service being availed is definitely of a better quality than its counterparts without marks. The next one is maximum retail price. Maximum retail price, everyone knows that all the goods or services will definitely have it printed on them. In spite of that, many a times, even if we come across instances like in railway station or bus stand, wherein products are sold at a higher price, most of the times we as consumers do not take effort in taking it forward, making a complaint. We tolerate it. So that should not be there. It might be petty, but then it goes a long way in achieving the object of Consumer Protection Act. And as we already know the redressal mechanism, it's not complicated. Even a layman could go ahead with this procedure. And then the next one is understanding the terms of sale. So before entering into a sale transaction, it's important to know what are the terms and conditions which are binding on us. So that also we understand in the e-commerce market, and with this digital platform, most of the times none of us pay attention to the terms and conditions. But then if we do, that could go a long way in protecting the interest of consumers. And then checking the genuinity of the product. little attention while we act as a consumer, while in the role of a consumer, could go a long way in avoiding us to be deceived, because we'll be able to identify what is genuine, what is deceptive. At that point, consumer could be a bit more aware, and then demanding a bill of the purchase. So whenever we are going for a sale or purchase transaction, it's mandatory to ask for a bill, because that is when even we could go ahead with the redressal mechanism, or there'll be a redressal for a grievance under the act. So that's mandatory. And then protecting information, that's more interesting. As a consumer, most of the times our sale or our transaction does not end just when we pay for it and then we avail the service or goods. But then they ask for unnecessary information, personal information, financial information. They ask us to fill in forms, lucky draw, lucky dips, this and that. So that point of time, as a consumer, we should be more cautious, and then try to identify what is genuine, what is not, and what we need to provide, what we don't have to. So over there, you'll have to, as a consumer, will have to exercise our right to choose, and then be cautious. That ways we'll be able to protect our right to data as well. And lastly, seeking redressal. This is a practice which we often come across in the market. So we as consumers, though we are aware of our rights and then the redressal mechanism, enforcement mechanism, everything, in spite of that, we let it go. So when there is a grievance, when someone violates our rights, though we know that there are remedies for it, we let it go. So that attitude should change, and then we should make, as each and every individual, each and every consumer should take a bit more effort and then try to take it forward, wherein we can get our grievances redressed under the enforcement mechanism. So that will also, that on an individual scale it might look like a small thing, but then on the whole it will help us achieve the object of the Consumer Protection Act. So these are a few tips to the consumers. On the ending note is that rights under the act, if complemented with the responsible behavior of a consumer, will go a long way in making this, achieving the object set under the act, way more efficient and significant. Thank you, one and all. Thank you, Dr. Harita ma'am. I sincerely thank you for providing me this opportunity, and I thank the organizing committee as well.
Thank you, ma'am, for educating us through this brief. By this, our discussion come to an end now. I request our chairperson, Dr. Harita Devi, Associate Professor in School of Excellence in Law, Director in charge of Research and Publications, Tamil Nadu Dr. Ambedkar Law University. Madam has a remarkable journey, presenting several papers in national and international conferences, published articles in journals, and also authored a book. I request Dr. Harita Devi ma'am for the closing remarks.
Thank you, Vignesh, for moderating the session from the morning. I think I am really surprised, or I would say I'm excited, because all the panelists, I don't have words to comment on Inba sir, because we all know he's an established arbitrator and he has already done so many presentations, and every day we see him on screen. But I'm talking about the remaining participants, or the panelists, I would say, our faculty members, as well as the research scholar Raghuvaman himself, as well as Aarti ma'am, Aishwarya ma'am, Divya ma'am, Mayappan Kumaran sir, everyone. I felt really very, very happy that the presentation was very, very clear and brief, and it was up to the mark. That's what I would like to say. At the outset, on behalf of the university, as well as our Vice Chancellor and everybody, I would like to congratulate all of you, because all the student volunteers and the faculty has made something come true. Because when I saw the book yesterday to be released today, I felt very happy that, okay, we can bring a book even in a week. That's what I was thinking. So I was right more. That's what I was really thinking. And today's presentation also on various aspects of the Consumer Protection Act. I'm not much on the act or on the things, but To be precise, the Consumer Protection Act 2019 has given us a bundle of rights which were absent in the 1986 Act. Because today we have a separate concept called product liability, and we have a specific concept saying the celebrities who are advertising are also liable, and the specific concept of the mediation. As Vijayan sir has very clearly explained about what will happen if mediation comes and what if no, my personal opinion is, in fact, when 1986 Consumer Protection Act came, it was I would say, a landmark in the field of consumer protection, because already there were so many legislations like starting from Contract Act, Sale of Goods Act, Essential Commodities Act, Food Adulteration Act, etc., where we are talking about consumer protection only. So from 1872 Contract Act, we have consumer protection. It's talking about buyer seller, 1930 Sale of Goods Act. So everywhere it is there. But taking into consideration the concept called consumer, he is the king, keep him on the top. Like that, this was the first legislation in 1986. But due to the developments that has taken place, and because of we moving towards globalization, liberalization, etc., today Indian companies are facing competition from multinationals. So too many, if for example, if a consumer goes to buy a soap or a shampoo or something, if you go to a supermarket, you will find at least 15 companies providing you soap. And if you start watching advertisements, every or another advertisement will be on soap. One advertisement will tell that you will be fair. The next advertisement will tell you will get a clear skin. The next will talk about perfume. Like this, it will go on all our soaps. So at least 10 to 15 companies are providing the same product. So that means, how are we going to fix the liability? So that is where the concept of product liability gains much importance. As everyone has pointed out, and rightly pointed out by the last speaker, it is not about the legislation, but it is how we are going to take it forward. So today's this discussion, which the university has organized, is for that purpose. You might think we are educating only some 100 participants who are here. No, we are educating 100 into how many people you can spread the awareness. So this discussion is only for the purpose of, or was conducted for the purpose of, bringing about the awareness and spreading the importance of Consumer Protection Act 2019. So how far we can make it reach. As a student representative, one is there. As faculty representatives, we have many. As an expert speaker, we have Vijayan sir. So we all should take up the mantle of taking this forward to all the normal consumers. First thing, we also should exercise our rights. At the same time, we can inform the common man around us. We need not go outside, or we cannot think of spreading it to India full and all. Nothing like that. We just spread awareness in and around us. Say our own staff, or our own people who are working with us, our own people at home, our family, to them, like that, we can take this forward. So that is the aim of this act. The salient features of the act has been explained in brief by all the presenters. So on the whole, my closing remarks would be, we have to take it forward. So consumers are protected, or maybe the right to safety, information, choice, redressal, everything is there in the act today. And the government has taken a very good step of giving, even you can file online complaints. No, you need not even go anywhere. Because yesterday while we were talking to someone, yes, I have a problem, I'm ready to go. But how? I'm not ready to file a case. Where will I go? When will I go? I have no time. All these problems comes there. So today, yes, there is a just sitting at home, take your phone through online, you can file consumer complaints. So that much down, the legislatures have come forward. Now it is our time to take it forward. So wishing you all a very happy World Consumer Day. But at the same time, keep in mind that we spread the awareness about this act. Thank you. Thank you for this opportunity. Once again, I congratulate everyone for your wonderful presentation. And I thank the Foundation of Sri Vijayan sir, for having coordinated with us for this discussion. Thank you. Thank you, Anand.
Thank you,
Thank
ma'am.
you so much, ma'am, for briefing the act and talking about the practical aspects, how the consumer, the different ways how the consumers are facing the problem in going for filing, and all other practical aspects in approaching the law. Thank you so much, ma'am. Now I would like to call Vignesh, our moderator and student coordinator, to propose a vote of thanks.
Thank you, ma'am. It's my honor for me to propose a vote of thanks. And it's my privilege to thank our Honorable Vice Chancellor, Professor Dr. N. Santhosh Kumar sir, for his continuous support for arranging events in our university. Because of this, our student community benefited an immense amount of opportunity. I thank him for making this event successful by his tireless support and enhances by his expertise. I further like to thank our Dean, Professor Dr. Balaji sir, UG Director Dr. Bhuvaneshwari ma'am, PG Director Dr. Kumdaratna ma'am, IQAC Director Professor Dr. Reddy Vari Revati ma'am, and all head of department and all assistant directors for their tireless support to make this program as successful. Further, I would like to thank all the panelists of today's discussion for sharing their knowledge and expertise and thereby enlighten us through this program. First, I would like to thank Dr. Harita Devi, Ma'am, Associate Professor, Director in charge of Research and Publications, the Tamil Nadu Dr. Ambedkar Law University, for closing remarks. And I would like to thank Professor Dr. Ranjit Oman Abraham sir, Registrar in charge for the Tamil Nadu Dr. Ambedkar Law University and Chairperson of this panel for opening remarks. I would like to thank Mr. Inba Vijayan sir, Managing Partner, KSPRI, for expert guidance in field of mediation. And I also would like to thank Mrs. Aarti Ratna ma'am, Assistant Professor Divya ma'am, Assistant Professor C.V. Aishwarya ma'am, Assistant Professor Raghotaman sir, Assistant Professor Mayappan Kumar sir for enlightening us through this panel discussion. I thank all the participants, scholars for their participation, and a special thank to technical staff, Mr. Darwin sir, for providing technical support. Thank you, ma'am.
Vignesh, you can post the feedback form in the chat box.
Yes, ma'am. Sure,
We
ma'am.
request participants to submit the feedback form. The platform will be open for next another 10 minutes. A informal vote of thanks. I thank Dr. Harita Devi ma'am, Dr. Ranjit sir.
I take leave because I
Yes,
have to
madam,
join
we are
in another.
busy. Very sorry, madam.
Back to 4 o'clock, right? Our program
Yes,
is next
yeah,
4
our
o'clock.
program is at 4 o'clock.
4.
So
Okay. I thank all the participants, whoever has joined. I think we have students from other colleges also. Thank you. Thank you, ma'am.
Thank you, madam.
Thank you.
Thank you, Vignesh. Thanks for moderating the session.
Thank you, ma'am.
Thank you so much.
Ma'am, is the Google
Yes,
form is
yeah. It's coming up. I'll check anyway.